Hello, and welcome to EzriLaw Firm podcast, the show that shares interesting issues about the law where you can relate with daily life. So today, the episode will be witnessing documents through Videocall.
Witnessing documents through video call. The prevailing technological advancement today in the form of electronic platforms such as Facebook, Twitter, Instagram, WhatsApp, FaceTime, Maybank to You, CIMB Clicks, and other similar mobile apps are fully utilized to conduct various types of interaction and commercial transactions between different parties. For conveyancing practice in Malaysia, apart from the instruments provided under the National Land Code, one of the most crucial documents is the Sale and Purchase Agreement. Fundamentally, there are procedures that must be adhered to in order to give a legal effect to the documents or transactions as set out in the statutory provisions. The question is, how far do these tools bind legally, and how far are they admissible in court? The rationale for the witnessing requirements of certain documents is to reduce the risk of people entering into fraudulent agreements and executing the documents without consent. An agreement is a contract when they are made by the free consent of parties, made in writing, or in the presence of witness, or any law relating to the registration of documents. It is clear that the law has provided this formula for an agreement to be valid contract, which it must be made in the physical presence of witness and must be consented by both parties. The issue at hand is whether witnessing documents can be done via video call such as FaceTime, WhatsApp, and Skype. In Malaysia, the Electronic Commerce Act 2006 or EA was legislated in order to deal with some of the latest technological strides, apart from contributing to business efficacy and the public at large. Therefore, it is important to make reference to this Act and also the Contract Act in determining the direction of this issue. What is the requirement of witnessing documents? We must first understand the requirements for attesting or witnessing documents. One of the crucial requirements is the attesting witness must certify that they were present at the time the document was signed. Dr. Seddon has raised the possibility that the statutory requirements may not necessarily require the witness to see the person signing the deed. However, that view has been criticized in Australia, as the use of the term witness in the legislation would suggest that the person in question has actually witnessed the activity attested. It was cited by Edelman J. in the Net Glory versus Carity as an authority clarifying that the witness is to be physically present to sign the documents as a requirement. The next requirement is the contract or agreement must be made by free consent and voluntarily by the parties, as specified in the Contract Act 1950. This is also supported by the case of Burns versus Lorec Mining, where it was held that the documents must be signed voluntarily, making the signatory liable for his or her own act. Specifically, the witness must be physically present for the signing, and the witness must be certain that the documents that letter received are the same ones that the witness had seen being signed, and the witness must be certain that the agreement was signed voluntarily, as there could be other possibilities in play, including someone behind a camera who is placing the signer under duress, coercion, and others. Next, we must understand the consequences of invalid witnessing. Firstly, the agreement may not have any legal effect, as stated in Net Glory versus Carity. Secondly, the agreement might become voidable if it breaches provisions under the Contract Act 1950. For instance, an agreement must be made by free consent without any uncertainty and others. Besides that, in the case of incorrect witnessing by a solicitor, it may lead the attestation to liability for misleading conduct or negligence, or amount to unacceptable professional conduct. In these circumstances, it is up to the parties to decide how to record the agreement in a way that they consider will provide sufficient evidence should they be required in the future. However, based on Section 68 of Evidence Act, if a document required by law is to be attested, it shall not be used as evidence until the attesting witness has been called for proving its execution. The party involved will be called to the court in order to prove the authenticity of the signature. No controversy shall arise if the agreement is executed by adhering to the statutory requirements, which typically includes that it is recorded in writing or in a document, which includes the components of signed and witnessed by the relevant parties. Parties will also need to consider the evidential weight which may be given to the signature if there is a dispute. For example, who in fact signed the document, whether they intended to be bound, or regarding the content of the document. Therefore, witnessing or attesting a document via video call may cause an uncertainty in many aspects and would lead the agreement to become invalid. To recapitulate, the rationale of witnessing of documents is to prove the genuineness of the documents and also to avoid risk of fraudulent agreements. The element of vagueness might emerge when deciding whether witnessing can be conducted via video call, although the basic requirements of witnessing documents can be fulfilled and the genuineness can be proven. The case remains that the documents must be witnessed physically rather than virtually for the time being, since it has a high risk to be contested, as there is no specific authority supporting witnessing via video call. However, as human beings progressing together with the technological advancement era, there is a possibility in the future that witnessing documents via video call can be adopted by practitioners with certain formalities or procedure to be followed in order for it to be applicable according to the law.
So, stay tuned to our next podcast episode for more interesting topic that we will share. Thank you for listening. Do follow our Instagram and Facebook, EzriLaw Firm. And I'm Zuleika, signing out.